Rahul ji, we can start.
Yes, sir. Please, sir.
Yes. Jamima?
Jamima, we can go ahead now. You unmute yourself.
Hello?
Yes, Jamima, you can start.
Yes, sir. Sorry, sir, for the inconvenience. So we'll start now.
Yeah, go ahead.
Don't just wait, dream and envision. Take a right step forward. This world is full of diamonds and gems, and we are having some of them here today. With this note, I would like to give my heartiest welcome to our respected principal, vice principal, our esteemed speaker for the day, Dr. Rahul Taneja, sir, faculties, and dear students. Myself, Jamima John, Assistant Professor, Department of Pharmacy Practice, Al-Ameen College of Pharmacy, welcome you all to this august event. Today, Al-Ameen College of Pharmacy celebrates the World Intellectual Property Day. The World Intellectual Property Day is the opportunity to celebrate all talented people around the world. The theme for this year for World Intellectual Property Day is Women and Intellectual Property, Accelerating Innovation and Creativity. In 2023, we celebrate the can-do attitude of women inventors, creators, and entrepreneurs around women of all regions are shaping the world through their imagination, ingenuity, and hard work, and often face significant challenges in assessing the knowledge, skills, sources, and support they need to thrive. So, let's work towards gender parity in intellectual property and unleash the ingenuity and creativity of women and girls everywhere so that we can build a better tomorrow. On this very special occasion, I'd like to invite our respected principal, sir, and president of Institution Innovation Council, Dr. M.D. Salahuddin, sir, to welcome the gathering.
Thank you, Jamima, for starting the program. And I take this opportunity as head of the institute and president of IAC to welcome the dignitaries who has joined by taking their time for this wonderful topic where we are supposed to celebrate tomorrow the World IPR Day, but our speaker Rahul Taneja ji is very much packed up in his activities that we have rescheduled it from 26th to 25th, our celebration of the World IPR Day. Thank you, Rahul ji, for accepting the invitation. We know distance is a matter, but still technology has connected us to reach out to all from the region from wherever we belong. So I'm really happy and thank you. And I also take this opportunity to welcome Dr. Jagshetty sir, the former drugs controller of India, who has taken his precious time to join to this today's webinar for IPR Day celebrations. I'm very much grateful and thank you so much, sir, for joining. I also take this opportunity to welcome to all the attendees, delegates, as well as the faculty members and students who have taken time to join to this today's World IPR Day celebration. And as you all know that how IPR has become very important. See, when I was student, though IPR was there, but it was not that much
Not audible, sir.
Sorry, I lost my connection. When IPR, how important it is in our profession is very important. Nowadays, we have seen that how infringement and the curbing of the rights of the innovations is happening. Probably today, our speaker, Dr. Rahul Taneja, will give you deep insight with various examples that how IPR has become important and the study of it, not only in the pharma, in the various fields. And today's topic taking up that women's role with IPR in pharmacy becomes very much important. I'm sure today's topic by the speaker will highlight in deep, will give a lot of information, and let us all join to this IPR Day celebrations with Rahul Taneja ji. I take this opportunity to welcome to all the dignitaries and the delegates for this IPR Day celebration hosted by the IAC of the Al-Ameen College of Pharmacy, Bangalore. Thank you so much. Welcome. Jai Hind. Over to you, Jamima.
Thank you so much, sir. Now I'd like to welcome our Vice Principal, Dr. Mubin Ghani ma'am, to talk a few words on the IIC activities.
Ma'am, unmute
Ma'am, please
yourself.
unmute.
Yes, you are able to hear me? Hello?
Yes, ma'am, audible, ma'am.
You have to unmute yourself, ma'am. It is again muted.
Yes? Yes, now?
Yeah, fine.
I'm audible? Yes.
Yep.
Now you
Yes.
are audible.
Yes. Good afternoon, everyone. A warm welcome to our speaker, Dr. Rahul Taneja, scientist, Haryana State Council for Science, Innovation and Technology, Panchkula, Haryana. And our principal, sir, Dr. Muhammad Salahuddin, sir, my colleagues, my dear students, and all participants for today's celebration, World Intellectual Property Day 2023, with the theme, Women and IP, Accelerating Innovation and Creativity. This celebration activity is organized today by Institution Innovation Council of Al-Ameen College of Pharmacy. As you all know, Institution Innovation Council is a program that has been launched by Ministry of Education and in collaboration with AICT for higher educational institutions to systematically foster the culture of innovation and startup ecosystem in educational institutions. Its role is to engage large number of faculty, students, and staff in various innovation and entrepreneurship related activities, such as ideation, problem solving, prototype designing, design and critical thinking, IPR, project handling, and management at pre-incubation and incubation stage. So we have been actively involved in conducting many activities like motivation sessions by successful entrepreneurs, many sessions on startup innovation and entrepreneurship, workshops on IPR, prototype designing, many competition for students, and also we have celebrated various activities like World Cancer Day celebration, World Pharmacist Day, World Earth Day, National Technology Day, etc. All these activities were conducted to encourage and motivate our young researchers, students, faculty members to become innovators and entrepreneurs. So today we are celebrating this World IP Day in our college and by conducting various activities. This day actually, World IP Day, it coincides with the date on which the convention established the World IP Organization entered into force in 1970. But officially it was installed in 1999. This is celebrated to help and build awareness, understanding of IP, and how it can support the ambitions and goals of inventors and creators and also entrepreneurs. Sir, for celebration of this day, we have also organized an essay competition for PG students on the theme of World IP Day, that is Women and IP, Accelerating Innovation and Creativity. So there will be the best 3 essays will be awarded tomorrow. So welcome you, sir, again, once again, and thanks for accepting our invitation to deliver your talk today on the topic role of IP in pharmaceutical sciences. I hope all our students, staff, participants get enlightened with your talk on role and importance of IP in pharmaceutical sciences. Thank you all. Over to you, Jemima.
Thank you so much, ma'am.
Yes, Jemima. Yes.
Now I welcome Mrs. Deepa ma'am to introduce our esteemed guest for today, Dr. Rahul Taneja, for today's IP Day event.
Good afternoon, one and all. I, Mrs. Deepa R., Assistant Professor, Department of Pharmacology, take this privilege in introducing the eminent speaker for today's session, Dr. Rahul Taneja. Dr. Rahul Taneja is working as scientist, Department of Science and Technology, Government of Haryana, Panchkula. He holds professional degrees including PhD in Pharmaceutical Science, Master of Intellectual Property Law, Master of Pharmacy, Master of Business Administration, Postgraduate Diploma in Intellectual Property Rights and Patent Practices, and the list goes on. As a scientist at the Council for Science and Technology, he facilitates the micro, small and medium enterprises of Haryana and Chandigarh for IPR-related issues. His portfolio further categorically includes dealing with patents, including PCT application, trademarks, designs, and copyrights. Dr. Taneja was also selected as Bentham Brand Ambassador for 2018-19 by Bentham Science Publication. He is also promoting and facilitating the research scholars, doctors, and scientists for the protection of intellectual property rights and to protect their invention and innovation. He has also delivered 5 times live broadcasting on news channel to the Enterprise of Haryana cluster and 2 radio talks on the day of World Intellectual Property Rights Day. He has 4 copyrights, 2 industrial design, and 3 patents filed in his own credibility. He has also been awarded for a significant contribution in healthcare by All India Institute of Medical Science, New Delhi. Dr. Taneja has 40 journal publications on various IPR issues and concepts, besides articles in various newspapers and newsletters. He has already delivered more than 320 specialized lectures in various national and international conferences and training programs on intellectual property rights in various institutions and industrial associations. With this brief introduction, I request Dr. Rahul Taneja to enlighten us regarding IPR.
Thank you so much, ma'am, for a wonderful introduction. Respected Principal, sir, Dr. M.D. Salahuddin, sir, former National Advisor, Drug Controller, Dr. B.R. Jagashetty, sir, respected Vice Principal, ma'am, other faculty members, and dear participants. First of all, congratulations to all of you for World Intellectual Property Right Day. And this theme is dedicated to women and IP in the field of technology and innovation. So I will try to share few schemes related to the government in which government facilitated and help the women to filing the patent application to motivate the women to enroll yourself in the field of intellectual property rights. So that is very important side because our country is basically, if you can see, government of India is already taking a lot of initiative to promote the women in the field of IP. Government has dedicatedly launched one scheme in which if you are a female applicant, then your patent will be examined as a fast track as compared to other applicants. So this is one of the major achievement of the government for the facilitation to women in the field of IP. So my slide is visible to all of you.
Yes, sir.
It is moving, sir.
Yes, it is moving.
Thank you, sir. Thank you. Intellectual means creation of human mind. Property जो आपकी अपनी होती है, rights जो उसके ऊपर अधिकार दिया गया है. There are two types of properties: tangible properties and intangible properties. Tangible properties, you have your own vehicle, house, car. You have some specific of type rights on your vehicles. Like you have a fundamental rights to use that property. Similarly, we have intangible assets. हमारी सोच and हमारी creativity. Some are scientists, some are painters, some are musicians, some are technocrats. कोई पोएम लिखता है, कोई कविता लिखता है, कोई गाना गाता है, कोई पेंटिंग करता है, कोई सिनेमेटोग्राफी वर्क करता है. Means every aspects of human mind we can protect with the help of IPR. Most of the time people think that this subject is only related to the pharmacy science background people, but it's not like that. Some people think like that it is important for the industry, but it's not like that. Suppose if you are doing a marketing, then IPR plays important role. If you want to start your own manufacturing unit, then it's play important role. If you want to start your own marketing company, then it's play important role, because for the selection of brand, for checking out that product is patented or not, that is also play important role. So in every field, for every stream, this subject is very important. So to protect the every aspects of intellectual assets, IPR plays a important role. There are two types of properties: industrial properties and copyright. So industrial properties, we have patent, industrial designs, trademarks, geographical indications, layout designs, trademarks, trade secrets, and protection of new plant varieties. Government of India has launched national IPR policy in 2016 with 7 different objectives. Legal framework, administration and management, commercialization of intellectual property right, enforcement, and human capital development. So the main objective of the government is to create the IPR awareness in our country, because most of the people doesn't know what is the difference between patent and trademark. I had delivered more than 1,000 talks across the country. Even I have interacted so many industries, MSMEs in India. They people doesn't know the difference between patent and trademark. They people think like that we can protect our brand name as a patent, but patent can be protected only by the technology, not by the trademark protection. Still, to create the awareness in our country, to aware the people how to protect our patent and trademark, this is the initiative of the national IPR policy. Because the problem is this, हमें सिखाया गया ज्ञान बांटने से बढ़ता है. So we are distributing our knowledge at free of cost. Now time has come. We have to protect our knowledge first. After that, we can distribute at free of cost or paid basis. It's up to you, because that knowledge is your and it is protected by you, by your name. So it is better you can take at a free of cost or paid basis. It's up to you, rather than somebody else can copy your invention, your idea, your technology, and take advantage of such type of things. You can protect your inventions. Patent. Patent is an exclusive rights granted for an patent is an exclusive rights granted for invention. It can be a product or it can be a process. It depends on your invention. You can protect product as well as process. One product manufactured by multiple type of process, then you can protect every aspects of that process. It doesn't mean that that product is already patented, but if you manufacture by a different process, then you can get a claim, right? Then you get a rights on that process, not on that product, but on that process also. Suppose if that product is expired from the patented invention, and you have manufactured different type of process to manufacture that device, and that is very economical significance and having a technical advancement, then you can protect it by the patent rights. And means the product is not patented, but your process to manufacture that product is patented. So you will get an advantage to manufacture that product. Government will give you a monopoly rights for that invention for 20 years. You can prohibit other persons to manufacture, selling, using your invention without your permission. What is the criteria of patentability? Basically, there are three criteria of patentability, and all the Patent Act is based on three criteria. First one is novelty, non-obvious, and industrial applicability. These three are the basic criteria to understand the patent. अगर आपने इसको अच्छे से समझ लिया, you will easily identify that if that product can be patent or not. Novelty means that thing cannot be published anywhere in the world before the filing of the patent application. Means it must be a new and not disclosed anywhere else, anywhere in the world. Means not in any journal, publication, newspaper, literature, any official communication to anyone. If it is already published in any domain, even by your name, then your patent will not be granted. So first you can file for the patent application. After that, you can proceed for the publication. Second one is the inventive step. Your invention must have some inventive step. Means your product must be having some new technical advancement feature or economical significance feature. Otherwise, it may be a new product or process. It depends on your invention. It is not necessary your invention must be complex or complicated. You will also get a patent right for the simple invention also. Even I was surprised that I was checking a few patented invention. Somebody has filed a hard gelatin capsule manufacturing process on just adding some new polymer on that invention, and easily they will get a patent rights on that invention. So it's not like that कि आपको patent मिल गया. It's like that जैसे हमें कहा जाता था ना पहले टाइम में आपके पास एक वरदान है and वो वरदान सिर्फ एक ही व्यक्ति को मिला जाता था. It's like that. You will get a patent rights that nobody can use such type of invention without you except across the world. If you protect your invention across the world, then you will get a monopoly rights. So few pharma companies making such type of things, they get a patent rights or few things. And they get a monopoly rights on that invention and taking advantage of lot of money for that inventions. Last one is the industrial applicability. Your invention must be useful for some industrial purposes. What is the meaning of industrial purposes? Means suppose if you are inventing some new things, but that is against our morality and system, these things cannot be filed for the patent application. अब मान लीजिए आपने कोई ऐसी एटॉमिक बम बना लिया जिससे काफी सारी पॉपुलेशन को हार्मफुल हो सकता है. Such type of things cannot be granted because this is against the morality and system. So this is the reason gene cloning is prohibited in our country, even key across the world, and the Atomic Energy Act is also implemented in such type of things. Nobody can claim for the compounds like uranium, beryllium, thorium, monopoly right for such type of things. So this is the three basic criteria of the patentable inventions. Next one is the grant of patent. Patents are territorial rights. If you are going to file a patent application in India, then your rights is only limited to the India. But if you want to file a patent outside the India, then you can submit by two ways. Either you can directly apply to that country, or you can submit by the PCT. What is the PCT? PCT is a patent cooperation treaty by which you can submit your patent application in multiple countries. By single application, you can file your application in multiple countries, but PCT is not a granting authority. It will just help you for filing your application to that country, and that country will decide your patent will be accepted or not. It is the jurisdiction of that country, and its decision depends on that country. Not on decision depends on the PCT, but PCT will help you for the patent searching, patent drafting, and other formalities. They will help you. Foreigner can also apply for the patent application. ऐसा नहीं है कि हम बाहर के लोगों को हम पेटेंट में फाइल करने से मना कर सकते हैं. इंडिया ने कुछ रिस्ट्रिक्शंस लगाई हैं चाइना के ऊपर, but still they people are open to file a patent application in our country. Patent Office Delhi. If you want to file a patent office from Haryana, Punjab, and Himachal, then you can approach Patent Office Delhi. I think you can approach Patent Office Mumbai or Chennai. I think Kolkata, Bangalore in Kolkata. Patent Office Kolkata you can approach, and Western Patent Office Mumbai, Southern Patent Office Chennai. So it is divided according to the jurisdictions. Country has divided into four jurisdictions in which their area is located. They can file a patent application in that office. And how to file a patent application? You can submit your patent application by hand also, by post also, and you can submit by e-filing mode also. Now we will talk about section 3 and section 4. Section 3 and section 4 is a very important parameter of the Patent Act. It will basically this is the exclusion of the Patent Act. किस किस चीजों का पेटेंट नहीं होगा, पेटेंट ऑफिस has elaborated in section 3 and section 4. Like section 3 is the frivolous invention and invention contrary to well established natural laws. Like जो machine 100% से ज्यादा performance देती है, like perpetual machines, that thing cannot be filed for the patent application. Section 3B is the commercial exploitation or primary use invention which contrary to public order and morality, like gambling machine, device for housebreaking. Such type of things cannot be filed for the patent application. Commercial exploitation of primary use invention which serious use to health, human, animal, plant, like embryonic stem cell cannot be filed for the patent application. Terminator gene technology, such type of things cannot be filed for the patent application. As such, discovery cannot be filed for the patent application. Newton's के जितने laws हैं, उनको हम patent के लिए file नहीं कर सकते because it is a theory, and theory as such cannot be filed for the patent application. Discovery as such cannot be filed for the patent application. So all the microorganisms is there naturally occurred in the nature. So this is a discovery, and discovery cannot be filed for the patent application. This is the reason natural microorganisms cannot be filed for the patent application. But if you have developed some genetically modification in your patent microorganisms, then you can approach for the patent application because you have input some research in this device, in this microorganisms, and you can claim for the patent application. Now this is very important for pharmaceutical people. India में जितनी भी pharmaceuticals की fight होती है products को लेके, that is because of the section 3D. The mere discovery of a new form of a known substance which does not result in the enhancement of the known efficacy of that substance. This is a very typical line and very confusing line. And even Honorable Supreme Court and High Court is also confused about this line because this is not an explanatory line. So explanation is this: किसी भी compound के crystalline form को आपने submit किया, just because of the new derivative of the new compounds, patent will not be granted until unless it is not regarded to the change in any efficacy or synergistic effect. वो नहीं change होगा, patent will not be granted. And in how much concentration it will be changed, that is not written in the section 3D. So if your invention showing some synergistic effect and some efficacy changes, then you can approach for the patent application. Otherwise, and new use of the patent application, patent will not be granted. Suppose आप कहते हैं कि पैरासीटामोल से अब एंटी डायबिटिक भी ठीक किया जाता है, डायबिटीज भी ठीक किया जाती है. On the basis of new use, patent will not be granted. You have to prove in which new ingredient you have to add in this compound, and on which basis you have to show your result. On that basis, your patent will be granted. Just because of new use, patent will not be granted. Section 3E. Suppose if you have two compounds, compound A which is showing antipyretic activity, compound B which is showing analgesic activity, and you are combining both the compound. Now you are saying AB is showing antipyretic activity as well as analgesic activity. So this is a obviousness, and on the basis of obviousness, patent will not be granted. So suppose if you are saying that it is showing a antidiabetic activity also, but still on the basis of new use, section 3D, patent will not be granted. So it means that you have to add some new molecule which is changing the synergistic property of a mixture. That thing can be filed for the patent application. Means all the things depend on the synergistic effect. Rearrangement and mere arrangement as such cannot be filed for the patent application. The method of agriculture and horticulture cannot be filed for the patent application, but the instrument used for agriculture and horticulture can be filed for the patent application. Section 3I. Any process for medical, surgical, curative, prophylactic, diagnostic, or therapeutic render them free from the disease or similar treatments as such cannot be filed for the patent application, like removal of cancer tumor, removal of dental plaque, surgical processes related to therapy, method of vaccination, and blood transfusion. These things cannot be filed for the patent application. But suppose if you have developed some new surgical apparatus, then you can file for the patent application. Surgical processes cannot be filed for the patent application, but surgical instruments are patentable. So you have to decide it is a process or apparatus. Process as such not patentable in the case of surgical, curative, prophylactic, and diagnostic. But you can file for the patent application of the instrument only. Diagnostic apparatus can be filed for the patent application, but diagnostic method cannot be filed for the patent application. Plant and animal whole as such cannot be filed for the patent application. Section 3L. A literary work, dramatic work, musical work, artistic work. आपने कोई poem लिखी, कोई कविता लिखी, कोई गाना गाया. Such type of things cannot be filed for the patent application because it is a subject matter of the copyright. It is not an invention. It's not an invention, so it is a subject matter of the copyright protection. Section 3M. Scheme for learning a language, method for solving a crossword puzzle, method of learning a language, method of teaching. These things cannot be filed for the patent application. Section 3N. Any manner or method of expressing information, spoken words, visual display, symbol, diagram. These things cannot be filed for the patent application. Traditional knowledge as such cannot be filed for the patent application. जितने भी हमारे आयुर्वेद ऋग्वेद में लिखी हुई चीजें इनको भी हम पेटेंट के लिए फाइल नहीं कर सकते. Section 3.4. Invention falling under Atomic Energy Act cannot be filed for the patent application like uranium, thorium, platinum, radium. These things are excluded from the patented inventions. This is the trends in the patent application. In 2014-15, approximate 42,000 patent application filed per year. In 2018-19, 50,000 patent application filed per year. And disposal is 14,000. And in 2018-19, disposal is 50,000. This is the ratio of the patent filing. Other national persons means who belongs to India and the foreign applicant. In approximate 50,000, 75% application filed by the multinational countries. Top 10 scientific research and development organization, CSIR, SAL, INCHIO, DRDO. Top 10 universities and institutions, IIT, Chandigarh University, Shule University. These are the top 10 institutions. Top 10 foreign resident applicant, Qualcomm, Samsung, Huawei. Where we are lacking basically in our country, India, approximate 52,000 patent application filed per year. United States of America 6 lakh, China 15 lakh, and Japan 2 lakh 80,000. This is the ratio of the patent filing in our country. In Maharashtra has filed maximum patent application, Tamil Nadu 2038, Karnataka 2138. So rest of the patent application filed by the other states. This is the certificate of the Indian patent. This is the website of IP India. You can yourself also file the patent application. It is not mandatory to hire patent agent. You can also enroll yourself for the patent filing. But you must write your patent application as per the specification by the Patent Act. Is software is patentable in India? Yes or no? As the software cannot be filed for the patent application because it is not considered as an invention. It is considered as a literary work and it must be protected as a copyright protection. But in US, the software is considered as a novel and inventive step, so they consider as a software is a patentable invention. Our business method is patentable in India? Yes or no? No, because rule and methods for doing a business are not regarded as an invention. Pure method as such are not patentable. There are total 30 forms for the patent application. You have to submit form 1, 2, 3 and form 5. 4 form you have to submit initially for the patent filing. Form 1 basically a one-page application in which you have to add your details. Form 2 is basically your complete invention about your research. You have to submit according to the Patent Act. Form 3 is the statement undertaking that you are not going to file a patent application outside the India without the permission of Government of India. Form 5 is basically declaration as to inventorship. This is the fees 1,600 for the small enterprises and 8,000 for the large entity. This is the anatomy of the patent document. Every information is given on the patent document. First one is the title of the invention, given like a research article. Title of the invention is mentioned on above is that. After that, inventor and the location of the invention given there. And third one is the assignee. Assignee is a very important parameter in the patent document because the rights belongs to the assignee, not to the inventor and inventors, because applicant who inventor is the person who authorized the assignee to file the patent application, and assignee may be any company, any individual, or any third person. Inventor is the who invent this application. Patent application number is given there also, and international searching patent references is also given there. This is the stages of the patent application. Initially, you have to file provisional specification or complete specification. After 18 months, it will be automatically published at the patent office website. Within 48 months from the date of filing, you have to request for the examination. If within 48 months no request has been submitted by you, then your patent will be cancelled and abandoned. After that, first examination report issued by the patent office, you have to reply of the FER. If he or she is satisfied by your reply, then your patent will be granted. Next is the trademark. Trademark also plays an important role in the pharmacy also. Nowadays, few people said like that, sir, patent तो समझ आता है लेकिन trademark इसलिए पढ़ाना बच्चों को. Trademark is also playing a very important role nowadays, especially in the pharmaceutical, because to select a new brand name for any new company, it is a very difficult task nowadays. Trademark is any sign, words, letter, color, or combination representation is considered as a trademark. It may be any sign, words, letter, representation. In simple language, who can distinguish from one person to another person, that is called a trademark. It is in the form of shape, color, name, graphic representation, etc. Trademark duration is unlimited time, but you have to renew after every 10 years. Trademark classes: class 3 for the soap, 5 for the medicine, 7 for the machine tools, 9 for the electronic components, 30 for the food items, 35 for the trading, 41 for the education services, 43 for the restaurant, and 45 for the legal service. So there are total 45 classes of the trademark. Market में question notice आता है, don't use our brand name. If you are using our brand name, then it is a legal that is a trademark infringement, and legal action will be taken against you. This is just a warning and question letter. आप मार्केट में आपको पानी की बोतल मिले, आप ले लेंगे ये विदाउट लेबल? No. One label can change the identification of the product. You can easily buy such type of bottle which is having some good branding. Can you purchase now? Maybe no, because the spelling is different. It looks like a similar to the existing brand. But don't say it's a duplicate. It's look like a similar to the existing products. So Bisleri has a value reputation and having some identification. Duplicate or original कहने का काम कोर्ट का है, not ours. So we can't say that it's a duplicate or original, but it's look like a similar to that brand name, and it create a confusion in the mind of the customer. Bisleri has a value reputation. It is owned by the Bisleri. Identify the symbol. It is a symbol of Nike. There are 4 types of trademark. Trademark in which supply the product. Service mark in which supply the services. Sorry. Collective mark supplied by the group of association. Certification mark like ISI, ISO. These all are the certification mark. Well-known marks like Mercedes, Lions, Godrej, Tata. These all are the well-known marks. These all are the trademarks which we are using 6 AM to 10 PM. सुबह 6 बजे से लेकर रात को 10 बजे तक सब ब्रांड नेम हम यूज करते हैं. So this is an example of the counterfeit products. Okay and Ole. Everything is okay? No, Ole is there and it look like a similar to the OK brand. Ole brand. Tone is same, shape is same, everything is same. This is the example of the Jaipur fruit team and fruity. No, it's very important for a pharmacist. Suppose if you are taking a medicine Medzol from some doctor and he can prescribe you one medicine Medzol, and you are taking a medicine for the allergic preparation that is called itraconazole 200, and you are changing your place from one place to another place, and you are saying to chemist, kindly give me a Medzol. Because of the same brand name, they can provide you isomeprazole or albendazole. And because of the similar brand name, sometimes it's a life-threatening also. Suppose if you are taking esmoprazole, that's not an issue because it's a anti-gastric medicine. But in the case of albendazole, sometimes it's a life-threatening also. So this is the reason trademark to copy करना it's a criminal offense. Sometimes people are using similar brand names, adding some new word, new blue line, best line. These are the popular example of the trademark. Parle-G. Parle-G is 17 साल हो गए इन्होंने अपना लेबल चेंज नहीं किया. Dairy Milk, Blue. So these all are the example of the how to select a trademark. It should be easy to spell. It should be easy to pronounce. Like Kodak and Dalda. As such, there is no meaning in the dictionary Kodak and Dalda, but it's a coined word. Mark should not be according to geographical name, like Bangalore Steel, Bangalore Pharmaceutical. So this is based on the geographical name. Avoid word which describe the quality of the goods. Best, perfect, super. This is the copy of the trademark certificate. This is a website of IP India. You can check yourself also any brand name. This is just an example. Suppose if you are searching display, then the following the search will be generated. Next is the industrial design. Industrial designs are granted for shape, configuration, ornamental feature, aesthetic feature. How it look like? You can protect any outer appearance of the device. It may be shape, configuration, and any article. But it does not protect the any technical feature. It protects only the outer appearance of the device. For the technical feature, you have to file the patent application. Packaging attendant, because packaging also plays important role in pharmaceutical science. टेक्सटाइल एंड ज्वेलरीज जितने भी ज्वेलर्स होते हैं बिग ज्वेलर्स ज्वेलरी सब अपने डिजाइन को ट्रैक करते हैं दैट नोबडी कैन कॉपी देयर डिजाइंस गारमेंट्स the design must be a new and original. Everybody knows that this is a symbol of hand and foot, but nobody seen chair like this. You can protect shape of the chair. Purpose may be same, but you can protect outer appearance. This is another examples. You can protect bottle shape also as industrial design. This is a copy of the certificate. Maybe the purpose is same, fuel efficiency is same. Outer appearance matrix, you can protect outer appearance. So this is the example of the industrial design. एक प्रोडक्ट में मल्टीपल टाइप की आईपी एप्लीकेशन हो सकती है. Like this is the example of the Dyson airblade. You have to insert your hand in the device. It will be automatically sanitized and dried. So this is the thing you can protect by the patent right, because this is the technology. You can protect brand name Dyson airblade by trademark, shape of the goods by the design, and the literature material by the copyright protection. Next is the copyright. Copyright are granted for musical work, artistic work, dramatic work, cinematography work. आपने कोई पोएम लिखी, कोई कविता लिखी, कोई गाना गाया, you can protect by the copyright. If your idea is in the expression form, then you can protect by the copyright. If your idea is in the technical form, then you can protect by the patent rights. As such, there is no official for the copyright. The moment you have create your work, it is protected by the copyright protection. But you have to prove that you are the first original author of that work. So for that, you have to file your application to the copyright office to just authenticate yourself. In which there are two types of rights: moral rights and economic rights, नैतिक अधिकार and financial benefits. जितने भी लोग उस क्रिएटिविटी में पार्ट करते हैं, उसका हर एक का नाम देना मैंडेटरी होता है बिकॉज ऑफ द मोरल राइट्स. एज यू सीन कि मूवी खत्म होती है, लास्ट में नंबरिंग आती है, स्मॉल स्मॉल वर्ड्स, चाहे हम रीड कर पाए ना कर पाए. इट इज मैंडेटरी टू ऐड द वर्ड्स ऑफ एवरी पर्सन हु पार्टिसिपेट टू द क्रिएटिविटी ऑफ दैट वर्क. इकोनॉमिक राइट्स, जिसने उस पर पैसा लगाया उसको फाइनेंशियल बेनिफिट कैसे मिलेगा. मोरल राइट्स में राइट ऑफ ऑथरशिप होते हैं, राइट ऑफ इंटीग्रिटी होती है, एंड इनएलिएनेबल राइट्स मिलते हैं. Copyright को कॉपी करना इट इज ए क्रिमिनल ऑफेंस. यू विल गेट ए फाइन ऑफ रुपीज 50,000 2 लाख रुपीज एंड imprisonment is 6 months to 3 years. Few things is allowed in the copyright fair use. Like अगर आपके पास कोई इन्वेंशन है, आप उसको रिसर्च पर्पस से यूज कर रहे हैं तो कर सकते हैं. कोई आर्टिकल को रिव्यू रिसर्च पर्पस के लिए कर रहे हैं कर सकते हैं. Review, criticism, education allowed, but not for the financial benefit. If there is some financial benefit, then you have to pay the royalty to that person. Geographical indication. Government of India is doing a lot of work in the case of geographical indication. A recent budget government has decided every state has a own GI. One GI every district. So every state has their own GI, every district. It is granted only 3 things: natural goods, agricultural goods, and manufactured goods. This is an example of the GI. Darjeeling tea, Mysore jasmine, Mysore sandalwood. So these all are the example of the GIs. There is a one organization, WIPO, who is celebrating World IPR Day. They are providing a free diploma to everyone, DL 101, 102, 103, and 104. Totally free of cost. You have to enroll yourself in this course, and after that you will get a certificate from the WIPO. Besides this, Government of India has taken initiative for the women's and starting a Kiran IPR Women's Scientist Scheme C, in which they are providing a financial benefit, PhD 40,000 and M.Com MTech 30,000 rupees. So most of the IP attorney in our country, female IP country, just because of these schemes. Besides this, if you are a woman applicant and you are going to file a patent application and you are requested for the early examination, you have to pay the fees to the government. Then government will exercise your patent application at a fast track and you will get a patent rights within 1 year. Thank you so much. And extremely sorry, I have a severe cough and still I am trying to cover all the parameters and to elaborate in details, and extremely sorry for that.
Thank you so much, Rahul sir. Sir, actually, bringing back to the chat box, we have questions. Have arised a few questions. Would you like to look into that, or shall I read it for you, sir?
Let me read, ma'am. Are analytical methods is patentable? Yes, analytical method is patentable. It depends on the which method you are going to file a patent application. Everything is patentable. It depends on how you can write your patent application. ये आपके लिखने पर डिपेंड करता है कि आपने उसको लिखा कैसे है. अगर आप लिखते हैं कि मेथड ऑफ ट्रीटमेंट, then it will not be granted, because the way you write the application, that is very important. Is section 3D common is worldwide? Yes, common worldwide, but it depends to country. Mostly it is covered across the world. In pharmaceutical sciences, process patent of API are very common than NCE patents. Why so? Because this is the reason, because our country is a developing country and we are thinking about to protect our new invention, but still there are a very lacuna in the systems how we can approach such type of things. So before going to file a patent application, you must be ensured that that is fulfilling the criteria of the patentability. Then you can approach for the patent application. How to apply a patent? European patent. European patent you can submit by two way. Either you can apply by the European Patent Office or you can submit by the PCT route also. Any other question? Why the patent validity varies worldwide? Mostly it is a 20 years, but कुछ cases में 21, 22 है. It depends on country to country, but maximum 22 ही है. And that is a very few cases जिसमें 22 है. उनको एविडेंस दिखाने पड़ते हैं कि उन्होंने किस रीजन से उनको टाइम एक्सटेंड किया. Generally is a 20 years only. Any more question? And I have one request to all of you. Kindly file at least one patent application, especially M.Com student, because you will get a examination report by the patent officer, who will check your invention detail worldwide. Where is your research is stand? मान लीजिए आप एक रिसर्च पे काम कर रहे हैं, आपको लगता है कि मुझे इस टॉपिक को पीएचडी पे भी करना है, आप पेटेंट फाइल कर दीजिए. पेटेंट एग्जामिनर आपको बताएगा कि ऑलरेडी इससे इन्वेंशन से क्या काम हुआ है. दैट यू विल गेट एन आइडिया कि हाउ वी कैन प्रोसीड फर्दर फॉर दैट इन्वेंशन. ये मैं आपको बेसिक पॉइंट बता रहा हूँ. हाउ टू गेट ए पेटेंट एप्लीकेशन, हाउ टू गेट ए ग्रांट फॉर ए पेटेंट एप्लीकेशन. दिस इज जस्ट ए इजी मेथड, easiest method. Any more question? Thank you, ma'am.
Thank you so much, sir, for your kind, valuable time and explaining each and every insight was very useful. I hope everyone would have benefited from this, sir. Bringing all to everyone's attention, we have feedback forms available. So there is a feedback form in the link below. Please click on that and give your valuable feedback. Thank you. Now I invite Ms. Bhakya Lakshmi to deliver the vote of thanks.
Is it audible?
Yeah.
A very good afternoon to all. It gives me immense pleasure to deliver the vote of thanks for IP Day event to all the dignitaries assembled here. Firstly, I would like to thank our esteemed speaker, Dr. Rahul Taneja, sir, for your valuable time and for honoring this function with your inspirational thoughts and beautiful insights. Your talk was very informative and it gave us more insights into intellectual property rights. Now, I would like to thank our respected principal and president of IIC, Dr. M.D. Salahuddin, sir, for organizing this event. I hereby thank our vice principal and IIC convener, Dr. Mubin Ghani ma'am, and IIC vice president, Dr. Salma Khanam ma'am, for your valuable efforts and time. I also take this opportunity to thank Dr. Lilita ma'am, Mr. Ragesh Panda sir, Mrs. Bhuvaneshwari ma'am, Ms. Jemima, and all members of IIC for their inputs and active participation. Last but not the least, I would like to thank all the participants for making this event a grand success. Thank you.
So end of this session. So thank you everybody who have participated in this event. And thank you all for your valuable time. It was a very good informative session, I believe. Good day to you all. Thank you so much.
Thank you.
Thank you, sir.